Hi, good afternoon if you are on the East Coast, and good morning if you're out west. This is Erin Lacey, and you are listening to Decoding the Final Borrower Defense Rule, the first in our four-part webinar series on the Department of Education's Final Borrower Defense Rule. So you'll see here the schedule for the entire series. In red is the new Borrower Defense Framework. That's the topic for today, and we'll be going through the other three topics. And this is pretty intense. We've put it close together, so we've got another one this Thursday, and then the next two are next Tuesday and Thursday, respectively. My name is Erin Lacey, as I mentioned at the outset, and I'm in the higher education practice here at Thompson Coburn. This is a law firm. We have about 400 attorneys, and I am an attorney practicing as part of the firm. Our higher education practice, I usually like to say, does things in sort of three buckets. The first is we provide regulatory counsel on federal, state, and accrediting agency laws and standards that affect institutions of higher education. This webinar series would certainly fall in that bucket. We assist with post-secondary transaction, contract drafting and negotiation, policy creation and compliance systems design. So all of those things you have to do, those vendor contracts, any type of deals, we like to help out with. And then we do occasionally represent schools, or I should say we represent schools on the occasion that they find themselves in administrative or litigation-style proceedings, so in program reviews with the Department of Education or accreditor actions, things along that line. Before I was here, I was in-house for several years with a post-secondary institution located in St. Louis, Missouri, so I have been on the other side of the phone and certainly and deeply appreciate the challenges, not just of understanding all these various regulations, but in implementing them, right? Once the webinar is done and you sort of left with, okay, what do we do now? And before that, spent many years in Washington, D.C. with a different firm, also in higher education. So here's the outline for today, politics and prognostications. We're going to do a little crystal ball work here at the outset. Then we'll talk about this new rule from 40,000 feet. We'll get into more detail regarding where it came from, and then we'll talk about exactly what the new rule looks like, and we'll break that down into these various categories. And lastly, as always, we try to provide you all with a couple of slides with resources. I will say this is going to be the longest of the four in terms of, or I should say, we're packing the most content into the 90 minutes of our four webinars in this one. So we'll have a little more space to breathe than the others. But as you know, if you've looked at the final rule, it was even in that tiny print in the Federal Register, well over 200 pages, which means that there's a lot to talk about. So we've been selective, but we still have a lot to cover. So politics and prognostications. Will this rule ever go into effect? That, if it is not, it probably should be the first question that you're asking. Well, you know, my crystal ball is as good as everyone else's, and I suspect that if you were paying attention to this recent election, your sense is that a lot of those crystal balls aren't so good. But I will tell you, I do think there is a good chance now, at least 50-50, if not better, that this rule will not go into effect. I think that is most likely, the way that that is most likely to happen would be through the Congressional Review Act. You may have heard of this. There have been some news articles. There's been press coverage. Back in 1996, this was an act that came into being, and it permits Congress within a certain period of time after rules have been promulgated to essentially pass what's called officially a resolution of disapproval, but essentially to kill the rule before it ever really goes in to play. It has to happen in the same way that a law is created, so it has to be passed by both houses of Congress, majority, and then signed by the President. Congress has 60 legislative days to do this. Legislative days are not calendar days, so that equals a lot more in the way of calendar days. I will just say that in this case, if they wanted to include the Borrower Defense Rule, this entire package, among those that are eligible to be killed by a Congressional Review Act action, they could do that because of when it was passed, so they have enough time. One of the really important things to note about a Congressional Review Act, really there are two. The first I have here on the slide, and that is it creates this expedited path, but it's filibuster-proof, right? So you don't have to get, it doesn't require the 60 votes, it's just a majority. So that's important because it means that if the Republicans really wanted to make this happen and they wanted to include this rule, they probably could. The other thing that's really important to note is when this happens, it essentially means that the agency is also banned from introducing a substantially similar rule at any point in the future. So if this particular rule were killed through the Congressional Review Act, or a legislative act taking place under the Congressional Review Act's authority, then it would not only potentially kill the rule, but also make it very difficult for the department, if they wanted to at some point years in the future, to come along and create a similar rule, or at least it would certainly create more hurdles. The other couple of things that could happen, I mean, even if Congress didn't act, the next administration could simply say, we're not going to enforce this rule. And then also they could go so far as to say, and we're going to begin a rulemaking process, the purpose of which is to essentially peel it back. So, Erin, you say, why should I stick around for 6 hours worth of content over the next 2 weeks if you're telling me the rule's likely to go away? Well, there are 2 or 3 reasons, right? I mean, the first is it's not a sure thing. Congress will not act, nor will the White House, for that matter, get involved if the bar defense rule is not a priority. And to the folks on the line, and certainly to someone like me who does what I do, you sort of say, well, how could it not be a priority? My gosh, you know, we've spent all this time thinking about it. But to those outside of higher education, it isn't always true that they're paying attention to these kinds of things. And right now, the incoming administration has a lot on their plate, and Congress also has a lot on its plate and to think about. So I don't think you can take for granted the idea that it will necessarily be on the hit list, meaning this rule. Now, it is true, I think, that the Republicans, Lamar Alexander, who's now continues to be the head of the Help Committee, looks like probably Representative Fox will be his counterpart over in the House. They are well aware of this rule. I know that they are very interested in seeing that it is dealt with. And your new Secretary of Education, Ms. DeVoe, she, though she is not from higher education, I suspect that she will be taking some cues, meaning her background is secondary elementary. She will probably be taking cues from Congress because the folks over there are so familiar, particularly, again, in the House and Senate Committees on Education, with the rule. But once more, all of this is to say there are a lot of things swirling around right now, and there are a lot of different pieces of rulemaking that Congress might decide to look at if it even went forward with the Congressional Review Act. It's also worth noting that Congress has only used this mechanism once before, even though it's been around since 1996. So, you know, I think there's a real possibility out there, but just keep in mind it has to be priority for it to really happen. So what that means is you might want to stick around and listen to get a sense as to whether you really like this rule or not, or where you see it as being particularly problematic. And if you think it's creating too much risk for higher ed or otherwise is a problem for you, you might want to say something to somebody. So encourage your association, speak to your folks in Congress, your representatives, make sure that it is getting on the radar. The other thing that's really important to note and remind is that, you know, the bar defense statute and the existing rule are already on the books, right? And they would not be subject to Congressional Review Act. I mean, remember, and we're going to talk about this later on, that piece of statutory language regarding bar defense and the accompanying regulation have been around since the mid-90s. So even if the new rule that we're going to talk about today were struck down, you're still going to have a bar defense concept out there, and you can't put the genie back in the bottle, as they say. You've already got tens of thousands of bar defense claims that have been filed with the Department of Ed. So those are going to have to be dealt with one way or another. All of this is to say, even if this rule gets killed, you're still going to have a bar defense mechanism in play. There are still going to be claims filed, and there are still going to be people at the Department of Education who are going to be tasked with dealing with those claims. And there is a lot of insight you can gather about how they're likely to go about doing that, even with the change in the administration. You're still going to have a lot of folks who are going to be thinking in the same way that this rule suggests that they would be thinking. So there's a lot of reason to pay attention. But do keep in mind, I think there is certainly a possibility that this rule could be struck down. So let's talk about it. The new rule from 40,000 feet, you've seen this slide before if you tuned into our series earlier this year on the proposed rule. The salient point here is the package as a whole is called often called in the press and elsewhere the bar defense rule, but there are various different components to it, right? The headliner and what we're going to talk about today is indeed the new bar defense framework. But you've got new elements of this rule that speak to financial responsibility, arbitration agreements, closed and false certification, discharge, misrepresentation, and still there is a new repayment rate concept that's stuck around. So we're going to be talking about borrower defense today, and then in the coming, on Thursday and next week on Tuesday and Thursday, we'll talk about some of these other elements as well. Implementation timeline, assuming that this is not all blown up. You know the negotiated rulemaking started early last year. Proposed rule came out June 16. Comment period closed August 1. The department promulgated the final rule on November 1st, right, in the Federal Register, and it is set to go effective July 1, 2017. Now, there are certain elements of the rule that are entirely under the control of the department that they have opted to voluntarily start implementing early, but you as institutions would not be required to implement the portions for which you would be responsible earlier than July 1, 2017. The borrower defense origin story, right? So in '93, Congress created the direct loan program. You guys know that. That was the first chip in FFEL, right? And as part of the direct loan legislation, Congress directed the Department of Education to specify in regulations which acts or omissions of an institution of higher ed a borrower could assert as a defense to repayment of a loan made under that part. So in other words, if someone had a direct loan and they weren't repaying it and the department went to collect on it, what Congress was saying is you, the department, should define what a borrower might say that their institution did as a defense to having to repay their loan. So the department's coming after me for my loan and I say, you know what, I shouldn't have to repay this because back in date X, my institution did Y, and that's a valid defense to repaying my loan. The following year, so '94, the department introduced the reg that is, as of right now, still the one that is in effect. It's at 685-206C, and this is the basic framework. So the department would initiate a direct loan collection proceeding. The borrower would assert that defense, whatever that act or omission they're claiming. They would say, this is what my institution did. The department would consider the defense and determine whether or not to forgive all or some portion of the loan. And then the department would have 3 years to initiate a separate action to recover the forgiven amount from the institution. This is the critical piece that I suspect many people on the phone are already aware of, but is not always readily evident to everyone when they first hear about this concept. And that is, the Department of Education maintains that it has the right, if it forgives some amount of a loan under these rules, to turn around and then collect that amount from the institution. And I will tell you, I mean, you can get into some sort of legal intricacies if you start to go down this road, but I expect that certainly the current administration and future administrations would probably take the view that the department has pretty broad ability not only to go after the institution, but to potentially go after its principals and affiliates as well to recover on these loan amounts. So there's real risk here for a lot of different folks if you have a situation where significant amounts are forgiven and the department determines to initiate a secondary recovery action. Under the current law, so this is under the law that exists right now, a defense includes any act or omission of the school attended by the student that would give rise to a cause of action against the school under applicable state law, right? So most states, for example, have some form of consumer protection statute, right? If you had a borrower who said my institution did X, they committed this act or omission, and that's a violation of my state Consumer Protection Act, right, statute, then that borrower could also turn around and say, and I believe that act or omission is the basis for a borrower defense, because whatever it is that the institution did gives rise or would have given rise to a cause of action under applicable state law. Applicable state law, typically we think of that as being the state law in which the institution is located, although there could be some discussion there if you're an online institution as to whether or not, or where the act or omission occurred, or whether or not if you're, again, a distance education institution, if the state laws would come into play of where the student was located. Some of that's still in the gray, so to speak. In 1995, there was a notice of interpretation that the department put out, so this was in the Federal Register, and essentially it was just their way of formally offering some guidance regarding this regulation, and in it the department's added that the cause of action not only must give rise to, under state law, but it needs to directly relate to the loan or to the school's provision of educational services. Now look, a cause of action, so what they're saying is the act or omission of the school has to relate either to the loan or the provision of educational services for which the loan was provided. That's still pretty broad, right? I mean, most of what an institution's going to do is probably going to relate to the provision of educational services. but importantly, there were a few things the department was trying to carve out. For example, personal injury tort claims, so slip and fall, or actions based on allegations of sexual or racial harassment, for example. So they were saying, look, there are different avenues for those claims to proceed, and those aren't an appropriate basis for a borrower defense claim. With regard to timing, under current law, a borrower can assert a defense at any time without regard to when the underlying act or omission occurred, right? So let's say I'm responsible for paying back my loan over 20 years. I could be in year 18. It could be 18 years ago that I graduated from my institution, and I could still claim that there was some act or omission that gave rise way back when, right? So in 1998, under state law, gave rise to a cause of action under state law, and then try to get my loans forgiven. And that could be not only future amounts paid, but an actual repayment of amounts that I had already paid into the department. But critically, under the current law, again, the department only has 3 years from the borrower's last award year to initiate a recovery proceeding against the school. So take that same hypothetical. Let's say somebody graduated back in 1998, and today they decide to say, oh, back then my school engaged in some sort of act or omission, gave rise to cause of action under state law. That's a valid defense. The department could forgive the loan, but under current law, they would not be able to then turn around and seek to recover that amount from the institution because that 3 years has more than run. So there's no discussion in current law of the process the department would follow in a recovery action, meaning when they turn around and try to recover from the school, there's no, nothing like in subpart G relating to fines, limitations, suspension, and termination, or subpart H would dictate sort of the processes when you're resolving audit or program review findings, nothing like that. However, in 1995, back in that guidance, the department acknowledged that schools were entitled to due process. And I will tell you, even if the department had not acknowledged that, that is a fact, that there would probably be, in the least, an argument that schools should get constitutional due process, if not some greater amount. So let's talk about the new rule. We're going to divide it into two parts. We're going to talk about the new framework and for dealing with claims that relate to loans that were made before July 1, 2017, and then we're going to talk about the new borrower defense framework as it applies to claims relating to loans that were made after July 1, 2017. And the reason for the distinction is there were certain things that the department was unable to do retroactively, right, relating to loans that had already been made or would be made prior to the effective date of the regulation. So you have slight differences in how these would play out. So for loans made before July 1, 2017, and the color coding here, the orange stuff is new. The blue stuff is basically unchanged from current law. So first of all, the department nixed the idea of there needing to be a collection action, right? So a borrower doesn't have to have defaulted on a loan or otherwise be in the process of trying to defend itself where the department is trying to collect on a loan. Instead, you could have a borrower who is an investment banker, making $150K a year, doing very well, just as an example, and that person could say, I just don't feel like paying my loans back anymore, and just download an application off the department's website and file it, right, and say, I think my institution engaged in some act or omission, without regard to whether or not they could or had been repaying their loans. The concern here, and I'm sort of implying this even though I haven't said it explicitly, is that this opens the door potentially to frivolous claims, right? There was some or encourages frivolous claim activity because in the past, someone had to be in a fairly difficult position before they would typically assert one of these borrower defense claims, and now that does not have to be the case. So it would seem that there might be an uptick in the number of folks who would consider just filing an application to see if they could get their loans discharged. Hopefully that's not true, but that would seem to be a risk. You've got a similar definition of borrower defense claim. So it's still causes of action under state law, but here the law has changed it so that the requirement that the act or omission relate to a loan or an educational service is provided by the school and paid for with the loan. That's now actually part of the regulation. Remember, previously that was just in that notice of guidance from 1995. So it's essentially the same standard, but the new law codifies this idea of loan or educational service having to be related to the act or omission. You have the same time limit on borrowers asserting a claim, which basically means there is no time limit, so a borrower can still assert a claim at any point. But you have new time limits on when the department can recover. Right, and those time limits in the proposed rule, you may recall, they had basically blown up the time limits, and the department said, well, we can more or less come after it, come after school at any point. they in the final rule, they've come up with a more complex scheme. So you have different time limits, and it's tied to the statute of limitations and or notice of the claim on the underlying claim. And we'll talk about that in a little bit. You have a new individual claim process and a new group claim process, and that is the case both for loans made before July 1, 2017 and after. And new methods for calculating relief. And this is another area where things really changed from the proposed rule. Okay, so what is the time limit on recovery actions? The department can initiate a recovery action against a school within the later of 3 years from the end of the last award year in which the student attended the school. So that sounds a lot like it used to be. Or the state statute of limitations applicable to the cause of action on which the borrower defense claim is based. So again, remember I had that hypothetical earlier and we said, well, what if you violated consumer protection statute, the state consumer protection statute? If the statute of limitations for a borrower to bring a claim under state law for that violation of the state's consumer protection statute were 6 years, for example, then what the department is saying here is, okay, then that 6-year limitation would apply on how long the department can turn around and initiate a recovery action against the school. But here's another really important wrinkle. The new rule would also provide, or does provide, that the department can initiate a recovery action at any time if the school had notice of the claim before the later of those 2 periods up there expired, right? So let's again say that the state consumer protection statute has a 6-year statute of limitations on whatever it is that the student is claiming the school did, right, to bring a suit under that state law. If the department, what they're saying is if you had notice as an institution within that 6-year period, then the department could actually seek to recover from you even after the 6-year period has expired, which begs the question, what constitutes notice? Well, actual notice from the borrower, so that's fair enough. A class action complaint that may include the borrower, okay? Or, and this is the one I think is particularly interesting though, written notice including a civil investigative demand or other written demand for information from a federal or state agency that has the power to regulate the school, conduct investigations, and into specific programs, periods, or practices that may have affected the borrower. So let me just boil this down, right? So what the department is saying is, okay, remember that Consumer Protection Act, right? It gives 6 years for a borrower to bring suit under, you know, when someone engages in this particular act or mission, you know, we'll say misrepresentation. Okay, so the question is, did you, school, get any type of notice that you may have engaged in a misrepresentation before that 6 years ran? And then the department could say, well, there was a state or federal agency or other entity that had the power to investigate the school and somehow issued you a notice that related to practices that may have affected the borrower. And so that happened in that 6-year period. So now, though it's 13 years later, we can still initiate a recovery action. You can see how there seems to be a little bit of an opening here to get way past that 6 years and to get really creative with whether or not an institution actually received notice or not. As a lawyer type, it makes me uncomfortable to say the least, because it makes it very hard for me to know when the door has really closed on the department being able to initiate a recovery action. So let's talk about the new framework for loans made after July 1, 2017. As you can see, it's all orange, which means it is all new. So again, you've got no collection action required. You've got a new definition of borrower defense claims. So for loans made after July 1, 2017, we're getting rid of this notion that it has to give rise to a cause under state action, under state law. We've got new time limitations on asserting a claim, new time limitations on when the department can go after a school to recover. Then you've got the new individual and group processes, and also changed from the proposed rule, new methods for calculating relief. So we're going to walk through all of this. First of all, what is the new definition of a borrower defense claim? Under the new law for loans made after July 1, 2017 and claims relating to those loans, a borrower defense exists where an act or omission of the school relates to the making of the loan or the educational services for which the loan is provided. Okay, so far so good. That's the same as the old law, and that's consistent with the guidance, right, from 1995, has to relate to the making of the loan or the educational services. And it has to have been, so that act or omission of the school has to have been the basis for a judgment against the school, the basis for a breach of contract, or the basis for a substantial misrepresentation. And those are, substantial misrepresentation we're going to talk about later is defined in federal law. right? So let's, a violation by the school, this is an important note, of an HEA eligibility or compliance requirement is not a basis for a borrower defense unless the violation would otherwise constitute a basis for borrower defense. So what do we mean by that? So if you have a late R2T4 payment, right, a finding in your annual compliance audit or your A133 that you send to the department or a program review, what have you, that on its face is not a basis for a borrower defense claim because it would not otherwise constitute a breach of contract or a substantial misrepresentation or judgment against the school, right? On the other hand, if you engaged in a substantial misrepresentation, well, that would be a violation of an HEA eligibility or compliance requirement because under the HEA, institutions are prohibited from engaging in substantial misrepresentations. But it would also still be a basis for a borrower defense claim, right? So it's a violation of an HEA compliance requirement, but it is also otherwise a basis for a borrower defense, okay? But this is helpful because it at least lets you know, and the department makes clear and includes in the law, this idea that if you've got technical HEA compliance deficiencies, someone can't jump on that and say, oh, this is a basis for a borrower defense claim. I should get all my loans forgiven. So let's go through those three: judgment, breach of contract, substantial misrepresentation. Judgment. So this would include any non-default, favorable, contested judgment secured by a borrower or a governmental agency based on state or federal law in a court or administrative tribunal of competent jurisdiction. So this is a fairly high bar, right? I mean, you've got to have a situation where you've had some tribunal, again, whether it be in a court or an administrative agency, that's actually made a decision after a contested process, okay? There is no limitation on when this type of claim could be brought. So a borrower could assert this type of claim theoretically even after they have paid off their loan. Right, so let's say they pay off their loan over 20 years, you're in year 25, they become aware of some act or omission, and you end up with one of these judgments. In theory, they could bring a borrower defense claim, right, and cite this judgment as a basis for the claim and seek to have their loan money repaid to them. Breach of contract. This would include any failure to perform under terms of a contract with a student without regard to materiality, which is a concern. The other concern, and a really important point for folks to appreciate, and I made this point when we were talking about the proposed rule, in the preamble accompanying the proposed rule, the department made clear that in their view, a contract could include an enrollment agreement and any school catalogs, bulletins, circulars, student handbooks, or school regulations, right? So I think particularly among the private, nonprofit, and public institutions that I've chatted with, when they hear about breach of contract, they immediately think about enrollment agreements and more likely the for-profit sector of higher education. But what's really important for folks to understand is the department is saying it is a valid basis, right, for a borrower defense claim if the borrower can show that you, the institution, breached a contract with them, and it could be any of these documents. So in your enrollment agreement, your catalog, your bulletin, if you said something and it later turned out not to be true, then a student could turn around and claim breach of contract. The other concern I have, again, goes to this materiality concept, and some of you have heard me give this example before. So let's say in your catalog or a bulletin you said, you know, we make tutoring services available on Tuesdays and Thursdays, and something didn't work out with your scheduling, and so one year while the student was there, it was on Wednesdays and Fridays instead. I don't see anything preventing a student from saying that was a breach of contract. In the catalog, it said it would be available on Tuesdays and Thursdays, and in fact, they did not make tutoring available on Tuesdays and Thursdays. Now, you and I would say, well, that's obviously not material, but here's the salient point. There's no materiality threshold for this breach of contract basis. So a student could still assert it. Now, we'll talk about later what that exposure might be and whether the department would grant any type of loan forgiveness, and that may or may not be the case. That they would, but it's still important to note that the student could, or the borrower could at least assert a valid borrower defense claim and initiate the process just based on that type of technical breach of contract. So again, as a lawyer type, this makes me very uncomfortable, and I'm sure that the institutions on the end of their phone are right now thinking, good grief, I mean, so will we have to go back and look through all of our collateral and all of these types of things, and you know, how do we, if we need to make changes, ensure that someone's not going to make a claim of a breach of contract down the road? There is no limitation on claims to discharge future amounts owed. So at any point when a borrower is still paying back their loans, say they're in year 10 and they have 10 years worth to pay, they could seek to have those future amounts discharged at any point, so at year 10, at year 15, et cetera. Now, if they get
to a point where they're talking about getting money back that they've already paid to the department, there is a 6-year limitation, and that's dated from the date of the breach, right? So if they graduated in 2000 and they claim that the breach of contract occurred in 1999 and it's now 2010, they would be limited in how much they could seek to get funds that they've already paid to the department back. Substantial misrepresentation, and I think this is the one, as much as breach of contract bothers me as a risk manager, substantial misrepresentation bothers me even more, and there were institutions, including a group of private nonprofit HBCUs that prior even to the proposed rule, I think it was prior to the proposed rule hitting the stands, actually reached out to the department and said, we're very concerned about this provision. And I think that concern is accurate and not misplaced. So a substantial misrepresentation, the borrower would have a basis to assert a borrower defense claim if they could show that the institution engaged in some sort of, quote, substantial misrepresentation, right? Now, this would include, I should say, a substantial misrepresentation made by the school or any contractual partner. So you as an institution are not only liable for representations that you might make, but also the representations that anyone with whom you contract might make. And if you're sitting at a large private nonprofit institution or state-run university, I want you to think about how many vendor contracts you have in place and how many people out there might be making representations on behalf of the institution, and it's sort of terrifying. So no materiality standard, again, but the borrower has to show actual reasonable reliance to his or her detriment. Now, that doesn't have to be material detriment, I should say. It just has to be that they reasonably relied on whatever the substantial misrepresentation was. And the department has argued that that is equivalent to a materiality standard, right? I mean, the borrower has to at least show that they did reasonably rely on whatever this substantial misrepresentation was, and that somehow it was to their detriment. I'm going to tell you in a minute why I still am very uncomfortable with this. But with regard to limitations, so once again, there's no limitation on claims, so a borrower can bring a claim at any point to discharge future amounts owed, but there is a 6-year limitation from the date of the discovery of the misrepresentation on claims to discharge amounts already paid. So let's talk about misrepresentation and substantial misrepresentation. I know this is a ridiculous slide, but there's a point to this. This is the department's definition, the federal definition of what constitutes a misrepresentation. Right. Now, the stuff in red is new. This rule has edited the language, right, to add this new portion. But even if this rule were not to go into effect, understand that everything that is black would still be there, right? So let me just read it to you. And I want to read it because I want folks to have an understanding regarding how incredibly low the threshold is for misrepresentation under federal law. Any false, erroneous, or misleading statement an eligible institution, one of its representatives, or any ineligible institution, organization, or person with whom the eligible institution has an agreement to provide educational programs or to provide marketing, advertising, recruiting, or admission services makes directly or indirectly to a student, prospective student, or any member of the public, or to an accrediting agency, to a state agency, or to the secretary. All right. So the first thing I want to point out is there's no element of intent here, right? So if you make a mistake, but it's false, erroneous, or misleading, it still qualifies, right? So a mistake is included. The second thing I want to point out is the representation can be made by not just the school or its representatives, but almost anyone that you have a relationship with, right? That you have an agreement or contractual relationship to provide almost any type of service that you might contract for. And the third thing is the representation doesn't necessarily have to be made to a student or prospective student. It can be made to any member of the public. So to be clear, if you have a vendor with whom you contract to provide advertising, and that individual inadvertently makes a false statement to a member of the public, that is captured under this definition of misrepresentation. A misleading statement includes any statement that has the likelihood or tendency to mislead under the circumstances. So I want to point out that would not only mean it could include an inadvertent or unintentional statement, it also could include a statement that is accurate, but has a likelihood or tendency to mislead under the circumstances, right? So now your vendor with whom you contract has made a statement to the public that is both accurate and unintentional, but has a likelihood or tendency to mislead, and it would be deemed potentially deemed a misrepresentation. Also includes a statement the rule clarifies that a statement is any communication, whether it's in writing, visual, or oral, right? And it also has this older language about a misrepresentation, including the dissemination of certain types of student endorsements or testimonials. And in the last line, misrepresentation includes any statement that omits information in such a way as to make the statement false, erroneous, or misleading. So it's not just a positive statement. You can actually also misrepresent if you fail to be complete in your representation. Again, even if it is accurate and even if it is unintentional. So what's a substantial misrepresentation? Any misrepresentation on which the person to whom it was made could reasonably be expected to rely or has reasonably relied to that person's detriment. Now, here's the really important thing I want to point out here, right? So you saw that extremely low threshold for what constitutes a misrepresentation, right? Here, they're not actually requiring actual reliance. It just has to be a statement upon which someone reasonably could have been expected to have relied to their detriment. So the department could say, okay, your vendor made a statement to a member of the public, right? And that statement was accurate and it was unintentional. But in our view, it had a tendency to mislead given the circumstances. Now, the person to whom your vendor made the statement didn't actually rely on that statement to their detriment, but they could reasonably have been expected to have relied upon it to their detriment. Now you have a substantial misrepresentation under federal law, right? So you can see why, as a risk manager, those of us who have been paying attention to this have been very concerned that if someone is able to establish that something constitutes a substantial misrepresentation, that would be a basis for a bar defense claim, because you see how low the threshold is. And all you would need is a borrower or a group of borrowers to try to be able to establish that an act or omission on the part of the school satisfied this extremely low threshold. And if that act or omission also related to the educational services you provide, they would have a basis for a borrower defense. The department has made abundantly clear that institutions, in their view, now this is the outgoing administration, are accountable even where mistakes are made. And this was from the Federal Register. We believe that an institution is responsible for the harm to borrowers caused by its misrepresentations, even if such misrepresentations cannot be attributed to institutional intent or knowledge and are the result of inadvertent or innocent mistakes. Similarly, we believe this is the case even for statements that are true but misleading. So if you felt like I was reading too much into the law or maybe taking too cynical a view of it, I wanted to make it very clear that this is what the department, the outgoing administration, thinks, and was very intentional about the way they went about crafting this language. So what's reasonable reliance? That is the one little piece they've added here for a bar defense claim to be valid, right? They've said, well, you know, in the case of actually asserting a bar defense, it's not just that it has to be a substantial misrepresentation in federal law, which again could mean that someone just reasonably could have been expected to rely on it. But in this case, to have a valid bar defense, they actually have to be able to demonstrate that there was reasonable actual reliance. So the department has said a finding of reasonable reliance will be more likely if the evidence shows that a school was. So essentially, the first thing to note is the department's making this determination as to whether or not they think someone in fact did reasonably rely. And that's just going to be based on whatever representations the borrower makes to them. But these are the types of things that a borrower would be looking at, the department would be looking at, and should this rule stick around, I have no doubt that a plaintiff's attorney would be keying in on and highlighting whether or not the school demanded that the borrower make an enrollment or loan-related decisions immediately, placing an unreasonable emphasis on unfavorable consequences of delay. So hurry up, pressure stuff, discouraging the borrower from consulting an advisor, et cetera, failing to respond to the borrower's request for more information about cost and financial aid, or otherwise unreasonably pressuring the borrower or taking advantage of the borrower's distress. Now, the department's not saying that in the absence of these things, it won't find actual reasonable reliance, but it is just saying if these factors are present, it will probably increase the likelihood that the department would make a determination that reasonable reliance was present. So all this having been said, let's talk a little bit about these claims and risk management, right? Because I didn't want to just throw the rule at you today, but I also wanted to give you some things to think about in terms of how you might manage the potential risk associated with this rule. And I will also note that even if this rule is killed by a Congressional Review Act or, its implementation is suspended, et cetera, these are still things that would be worthwhile to think about. Okay, risk assessment. So claims will be easier to bring, right? The rule permits defense claims to be brought outside the context of a collection action and without regard to whether the borrower is able to make loan payments. So the rule does not include any materiality standard for breaches of contract. We talked about that too. Also, the rule does not include, to my point, a bona fide materiality standard for substantial misrepresentations. You have to have reasonable reliance, but I think a borrower could establish a claim pretty easily by providing evidence that the institution made a misrepresentation and just claiming reasonable reliance. Moreover, and this is a really important point we'll talk about later, in group claims brought by the department on behalf of large groups of borrowers, actual reliance is presumed. So let me give you a hypothetical, right? So let's say the Department of Education is driving down the street and your school has a billboard on the side of the road. And I'm in St. Louis. When I drive into work every day, I will tell you almost every billboard between my house and downtown where I work is for an institution of higher education. It's really incredible. And I will also tell you that they are almost all billboards for traditional schools, state and private nonprofit. So I know a lot of you guys do lots of different kinds of advertising, and billboards are part of that plan frequently. So let's say the department's driving down the street and they look up and they see something and it says, come to University X, check out our new engineering program. And in the background, there's this picture of a lab. And it turns out that whoever built your marketing and created that billboard image used a picture of a lab that is actually associated with one of your campuses that's on the other side of the country, not at your main campus right here in town. And so they get a call from a student. The student says, well, I enrolled at the school, and I thought that the lab in that picture was going to be part of what I would be able to use. That was the kind of facility that would be present, and it's not there. It turns out that picture's from a different school on the other side of the country. And that induced me to enroll, and that was a substantial misrepresentation or just a misrepresentation, what have you. And the department says, we think it was a substantial misrepresentation, right? So they decide to initiate a group claim, and they say, okay, every borrower who enrolled in your institution during the period that that billboard was up and actually enrolled in your engineering program, we think that they have a valid borrower defense claim. And then you say, well, wait a minute, okay, it was inadvertent, all right, but it was factually inaccurate, so maybe it was a substantial misrepresentation. Someone could have reasonably relied on it, but where's the actual reliance? And the department says, aha, but in the context of group claims, we are presuming that everyone who enrolled in the institution during the entire period that this billboard was up actually relied on the billboard. And so now you as an institution have to rebut that presumption. That's where this comes in, and you can see how dangerous that can be. Because now you've got this task of having to show that all of these individuals did not rely on that billboard. The departments also increase the ability to recover from institutions, so they can initiate recovery actions years after the alleged act or omission. They can reopen claims to review new evidence. We'll talk about that a little bit more when we get into process. And they can even certify and bring group claims, which is something I was alluded to in a minute. And again, we'll talk about that. It's extraordinarily difficult to control all the representations made by a large institution, right? And this is one reason. It's interesting because I was having some conversations with some folks actually who were present at the negotiated rulemaking on behalf of some traditional institutions. And the department represented to them, I was told, that, you know, this really isn't about you guys. You're at an ethical institution. You don't have anything to worry about. Okay. Here's my concern, though. If you are at a large private nonprofit or state institution and you have thousands of employees, or even if you have 10 employees, there are probably a few knuckleheads around, right? I mean, all of us work with folks who occasionally make bad decisions. If you read the first page of Inside Higher Ed or the Chronicle on almost a daily basis, you can spot a president or a professor or a chancellor who has made a bad decision and probably been kicked out, right? Vendors are even more difficult to monitor, and a lot of larger institutions have even more vendor contracts. We don't know whether the next administration will keep the promises made by the drafters of the rule. That's also a major concern, right? So the people who were talking to these negotiators, and this is a problem anytime you're talking about agency rulemaking where you have changes in administration, those people making those representations when this rule was being designed, right, aren't going to be the ones who are enforcing the rule. Now maybe the ones who are incoming with the next administration will take, you know, an easier view, but maybe not. And then, you know, if the rule sticks, what happens 4 years from now when the next administration comes in, which is why a risk management type like me, you know, I want to see all those procedures and I want to see all those protections built into the rules so that no matter who is enforcing it, you know that institutions are going to have a fair shot at defending themselves, right? I mean, that's sort of my take on things. But all of these are reasons for risk. So what do you do to manage the risk? Keep policies, marketing materials, and other external communications lean and flexible. What do I mean by that? It has been my experience, and I work with a lot of schools on a lot of different kinds of policies, that over time someone writes a policy and then someone adds to it and then it gets modified and someone hears about a new rule so they add another piece and you end up with these Franken policies, right, that are bloated and often contemplate lots of odd little specific scenarios that someone has included in response to some specific issue that came up 3 or 4 or 5 years ago. The first thing that any good litigator will tell you about a policy is don't have a policy unless you plan to follow it. And if you're not going to follow it, get rid of it. Bloated policies that contemplate very specific types of scenarios are more likely to hurt you than help you because they are painting you into a corner, so to speak. The department, if it comes on site or if a student is trying to claim that you breached a contract or engaged in substantial misrepresentation, you're just giving them all of this stuff to look through and try to find where you might have slipped up. So what you want to do is you want to keep your policies lean, right? You want to keep them limited to the things that you need to discuss, but you don't want to include things that you don't need to discuss. The other thing when I say flexible is you don't have to contemplate every scenario. Instead, you say, categorically speaking, if certain things come up, this is the process we're going to use to handle them. But you don't try to specify a process for every different type of scenario that might arise. And that way you've got some flexibility, but you're not committing yourself to any specific resolutions, and more importantly to resolutions or protocols that you're not prepared to keep. Review and enhance controls in vendor contracts. So what I mean by that, you've got all these agreements, right, with third parties that do work for you and maybe making representations on your behalf. You want to have the ability, if people are designing marketing and other types of materials for you, certainly to review and approve that before it goes out, or at any point in time to have some sort of audit mechanism in place so you can ask them to show you the stuff that they're generating, right? And those types of provisions should be in those vendor contracts. Also, if you can get it, you want explicit indemnification for borrower defense liabilities. So in other words, if I have a contract with a third party that's going to go out and make representations on my behalf, I want in that contract something that says if you go out and you make a false statement and it becomes the basis for a borrower defense claim and the department turns around and seeks to recover from me $25,000, then you're going to indemnify me for that because you made the representation. Right? Now, maybe your vendors will go for that, maybe they won't. It's going to depend on the leverage you have in that relationship. But these are the types of things you ought to be thinking about because the representations your vendors are making on your behalf potentially will lead to liability for you in the borrower defense context. And this is one of those things, by the way, that is true even if this new rule gets killed. Because there is still a borrower defense concept on the books, people are still going to be filing borrower defense claims, and the definition of substantial misrepresentation and misrepresentation are still out there. So you can still end up in trouble potentially. Ensure behaviors highlighted by ED are prohibited in policy and practice. So remember that list I read earlier, and I said if these factors are present, it makes it more likely the department will have a finding of actual reliance. Well, you want to explicitly prohibit those behaviors. Right? So if you've got a code of conduct for admissions personnel or other faculty or staff, include that kind of thing explicitly, right? And occasionally see if you can work out a monitoring enforcement function to make sure that that kind of stuff isn't happening, right? If you've got marketing guidelines, make sure that that is included in your marketing guidelines because you certainly want to be able to say to the department, look, these things that you look for, those are not present, and in fact, we prohibit them as a matter of policy. All right, so the really interesting thing I thought that the department did in the proposed rule, and I don't mean in the preamble that accompanied the final rule, I mean in the actual regulations itself, it gave a bunch of examples, hypotheticals of potential borrower defense claim situations. And it said, this is the hypothetical, and this is the, you know, and it spoke to whether they thought there would be any relief that should be granted. So I wanted to walk through these with you because I think that they, one, are extremely interesting and also give you a great deal of insight into what the folks who designed this rule were thinking, and also insight into potentially how the department will treat borrower defense claims going forward. Because remember, even though you've got a new administration and a new secretary and you may get a lot of new appointees, right, below the secretary but above the staff level, there are still going to be people at the department, people who are there now, who are potentially going to be helping or assisting with the resolution of all these bar defense claims that are out there. And this is the thinking that has been pervasive within the department, and these resolutions, even if they aren't part of the rule, may still be the kind of thing that these folks are looking to and trying to figure out how to manage bar defense claims that are still coming in. So claim number one, a school represents to prospective students in widely disseminated materials that its educational program will lead to employment in an occupation that requires state licensure. So this is tricky business, right? If your graduates have to get some form of state licensure to practice and you're telling them my educational program will permit you to sit for that licensure. The program does not, in fact, meet minimum education requirements to enable its graduates to sit for the exam necessary for them to obtain licensure. So this seems pretty cut and dry. And the department indeed says borrowers who enrolled in this program during the time that the misrepresentation was made should receive full relief. As a result of the school's misrepresentation, the borrowers cannot work in the occupation which they reasonably expected to work when they enrolled. Accordingly, borrowers received limited or no value from this educational program because they did not receive the value that they reasonably expected. Now, that's an interesting final point. If someone got through the entire program and they were educated and received credits and a lot of knowledge, certainly there was a misrepresentation there. I think it's interesting that they would assert potentially that they got no value. But what's the real risk management lesson? Carefully review and map licensure requirements for graduates in all your applicable jurisdictions, right? Because the hypothetical, and it's easy for us to do this, trust me, you see these hypotheticals and you think, well, one, we would never do that, right? And two, this seems very cut and dry. This is an awful school that they're talking about that will go out and say these things. But, I used to work with a school that had an alcohol and abuse counselor program. And the state requirements in each state for what it required to be able to actually practice as a licensed counselor in that area were vastly different. And in some states, there were multiple paths to being able to achieve the licensure. So, for example, if you had so many credits but this much experience and shadowing, then you could sit for licensure, or if you had twice as much education but half as much experience. So it became very complicated for an institution offering an online program to keep up with all those different licensure requirements, to disclose them accurately to the students, and to understand whether and to what extent the education they were offering would permit that person to sit for licensure. In some cases, they would not be able to sit for licensure immediately because you're only able to provide the educational component, and they still have to go out and get so many shadowing hours or whatever before they can sit for the license. So that's tricky business. It's not as cut and dry as it always seems. And the risk management lesson here is when you're in those types of tricky spaces, you need to make sure that you're really paying attention. Ensure that plain disclosures are made and acknowledged, i.e. signed by the student prior to enrollment, and update those things quarterly because laws change. I'm not talking about every disclosure you have necessarily, but the ones relating to licensure for programs that are designed to lead students to licensure are important, and you need to keep on top of them. That's been a theme with accreditors, with the Department of Ed, and lots of different areas. Okay. So number two, a school states to a prospective student that its medical assisting program has a faculty composed of skilled nurses and physicians and offers internships at a local hospital. The borrower enrolls in the school in reliance on that statement. In fact, none of the teachers at the school, other than the director, is a nurse or a physician. The school has no internship program. The teachers at the school are not qualified to teach medical assisting, and the student is not qualified for medical assistant jobs based on the education received at the school. So I appreciate the department has really piled a lot on here. I mean, they've at least made it easy for us to come to a conclusion. I think this would be much harder and more interesting if it was only the fact that not everybody was a nurse or a physician, right? So there would be some question, well, what if two of your folks are nurses and physicians, one's a nurse, one's a physician, you only have 4 faculty members. Is that still problematic? The fact that they have no internship program here is an outright misrepresentation, but if you took that off the board, I think it becomes a much more complicated scenario because some programs only have 3 or 4 or 5 faculty members. It's also interesting that the department includes the conclusion that the teachers at the school are not qualified to teach medical assisting. Because it's interesting as to on what basis the department has reached that conclusion. They seem to be making a value judgment as to the expertise and ability of the school's faculty and staff. And I'm very interested in how they are making that determination and what evidence they are using to reach their conclusion. Here, when you combine all of those things, it is not surprising that the borrower would receive full relief. None of the teachers at the school are qualified. Again, okay, so the department for some reason has reached that conclusion. There was no internship. That seems a flat misrepresentation. And in contrast to a reasonable student's expectations, based on the information provided by the school, the typical borrower received no value from the program. So again, the department has reached this conclusion that there is no value. All interesting, but taken together, hard to see how any resolution other than full relief would probably be appropriate. So what's the risk management lesson? Keep your marketing and admissions materials current, right? Because sometimes you may have a situation where you have a smaller program of 4 or 5 faculty members, and it may be true that they are all, you know, physicians or nurses or meet some other criteria, and then you have some turnover, and you have a couple of people who leave, right? And you're not doing anything, you know, you're not seeking to misinform a student, but your admissions reps and your catalog still suggest that everyone there meets that qualification. It's no longer true. So again, you have to be rigorous with keeping up to date in your collateral, right? Keeping your collateral up to date, your catalogs, your faculty lists, things like that, when you have changes. And sometimes you've got faculty and program administrators who are really in charge of these changes and may not interface directly with the folks who are publishing a catalog or putting together a school bulletin or the website. So you got to work on coordinating those folks and making sure that when changes happen, they are reflected and flow through in your collateral. The other thing is keep your admissions personnel up to speed. You know, when we see some of these hypotheticals, there is sort of this assumption, I think, that whoever is making these misrepresentations is doing it on purpose or is up to no good. But, you know, if you've got a program change that occurs and the catalog isn't updated and nobody tells your admissions or a team or whoever is in your office of admissions, they may not know. And so it is a misrepresentation. It's inadvertent, right? And there's no ill intent, but it's still a misrepresentation. So again, it's not just a matter of coordinating between those folks who are in charge of the academics and where those representations are made, but coordinating on a regular basis to avoid inadvertent misrepresentations. Number 3, an individual interested in becoming a registered nurse meets with the school's admissions counselor who explains that the school does not have a nursing program, but that completion of a medical assisting program is a prerequisite for any nursing program. Now, most of us know on this line, if you've been in the allied health space, that that's not true. Based on this information, the borrower enrolls in the school's medical assisting program rather than searching for another nursing program, believing that completing a medical assisting program is a necessary step towards becoming a nurse. After 1 year in the program, the borrower realizes that it is not necessary to become a medical assistant before entering a nursing program, and the borrower's credits are not transferable to a nursing program. The borrower should receive full relief. Because it is not necessary to become a medical assistant prior to entering a nursing program, she's made no progress towards the career she sought, and in fact, has received an education that cannot be used for its intended purpose. What's the risk management lesson? Document student interests and career objectives in an application for admission. Well, Erin, what do you mean? Because it was pretty cut and dry here. Well, remember, the basis of the claim, it all starts with what the individual was interested in. Because your admissions counselor may come up to you and say, well, that's not the conversation we had at all. We talked about, she said, I'm interested in nursing, and we said, well, we don't have anything to do with nursing, but we got medical assisting, et cetera, right? But on the back end, you've got the borrower who's saying, well, this was the nature of the conversation, and what I was interested in was a nursing program, not a medical assisting program, right? And there's no way of refuting that characterization of the initial interaction. By the way, it could have been true, don't get me wrong, but one way you can try to remove any doubt as to whether or not that is true is to have in your application process some place where a student is asked to state their interest. Why are you enrolling in this institution? What is it that you want to do, right? And if they come in and they say, I really want to be a medical assistant, my mom's a medical assistant, it's all I ever wanted to be, and then they show up 3 years later and say, well, I really wanted to be a nurse, and I was told that this was well, that's a different situation, isn't it? Because you say, well, you came to us saying you wanted to be a medical assistant. At least cast a little doubt. Again, I'm not trying to suggest, I mean, let's just assume for purposes of this hypothetical that the department, that it's true, right? And that would clearly be inappropriate if someone came in and said, I want to be a nurse, and you misled them. But I think it is still really important for institutions to have a mechanism for documenting student interests up front. What is the program you want to be in, right? Number 4, a school tells a prospective student who is actively seeking an education that the cost of the program will be $20,000. Relying on that statement, the borrower enrolls. The student later learns that the cost for that year was $25,000. There's no evidence of any other misrepresentations in the enrollment process or of any deficiency in value in the school's education. The borrower should receive partial relief of $5,000. The borrower received precisely the value that she expected, and the school provides the education that the student was seeking but misrepresented the price. So here's what's interesting, though. You all know who actually work at institutions that prices can change, right? I mean, typically there are certain things that are set, you know, tuition, credit hour costs, things like that, but you've got books, tuition, equipment fees that can vary depending on the books the student decides to buy. They may come in and say they want to do one set of classes and change their mind at some point. They may drop, or you may have some sort of adjustment in their pricing. And that all makes this a lot, you know, it's pretty rare that someone comes in and you say, it will cost $20,000. And at the end, it's, oh, whoops, it costs $25,000, right? But what I think you can do is ensure that tuition and fee information is clearly documented, and that if program or credit hour costs are subject to change, such qualifications should be plain and acknowledged in writing by the student, right? So you need to make clear if it's estimated tuition, if it's estimated cost for books, you know, supplies, equipment, et cetera, so that when the person comes back and says it turned out to be $25,000, you can say, well, one, we made clear that it was estimated and why it was estimated, right? Because you're charged the cost of books at the time, you know, that they cost us at the time you go buy them, or you selected to go off campus and buy your books, or et cetera, right? There are a lot of reasons that the actual amount could vary, and you need to make clear that it can vary and why in your enrollment agreement documentation, and then I would have them acknowledge that. So if they come back, you can just say, look, this was the understanding, we were very clear about this, and also this is why you had these additional charges. If program or credit hour costs are increased, ensure those increases are plainly communicated to students in advance. That's the other thing. Like if you're doing an institution-wide tuition increase, or, you know, your credit hour costs are going up, boy, put something out so that you can make sure to say, look, we notified everyone of that beforehand. And typically in your catalogs and other places, you want to make sure to reserve the right to change tuition and fee and costs and make program changes and all those kinds of things as well. Number 5, a school represents in its marketing materials that 3 of its undergraduate faculty members in a particular program have received the highest award in their field. A borrower choosing among 2 comparable selective programs enrolls in that program in reliance on the representation about its faculty. However, although the program otherwise remains the same, the school had failed to update the marketing materials to reflect the fact that an award-winning faculty member had left the school, or more than one. Although the borrower reasonably relied on a misrepresentation about the faculty in deciding to enroll at the school, she still received the value that she expected. Therefore, no relief is appropriate. So risk management lesson, be a selective institution with award-winning faculty. That's a joke. I hope somebody laughed at that. So there is a difference between this hypothetical and the one we saw earlier, right? The one with the nurses and the physicians, that was one piece of it, but they also didn't have an internship at all. The department concluded that no one there was capable of teaching the program or qualified to do so. Here, none of that is the case. The only thing at issue in this example is the fact that some of these award-winning faculty weren't present. There's no question as to whether or not those who remained were able to deliver the program. Now, it still is interesting that the department would go through the trouble of characterizing the school in this case as a selective institution, because it sort of raises the question, well, what if I'm a non-selective institution and I have a similar mistake? Would that make a difference? The only reason I can justify the department, or think that the department would have done that, is to highlight for selective institutions that they are also covered by this rule. Right? So it's not that the rule applies differently. I think what the department is, I hope what the department is trying to point out is that the rule applies to everyone, right? So presumably, if in this case they had added the fact that there was no internship and it had been represented that there was one, you would have seen a different outcome. Number 6, an individual wishes to enroll in a selective, regionally accredited liberal arts school. The school gives inflated data to a well-regarded school ranking organization regarding the median grade point average of recent entrants, and also includes that inflated data in its own marketing materials. This inflated data raises the place of the school in the organization's rankings in independent publications, and the individual enrolls in the school and graduates. Soon after graduating, the individual learns from the news that the school falsified its admissions data. notwithstanding this issue, degrees from the school continue to serve as effective, well-regarded liberal arts credentials. Now, once again, it's unclear to me why the fact that the degrees are well-regarded liberal arts credentials would necessarily impact whether or not it was a misrepresentation or a substantial misrepresentation, right? I mean, that shouldn't have an immediate impact. But I think what the department is one, again, indicating is that part of this is that it applies to everyone. So we're making clear that even regionally accredited selective liberal arts institutions are covered by this rule, which is very true. But the other thing they seem to be suggesting is, you know, part of the equation here is how much value is the student really getting. I object to the idea that I think a degree from an effective, well-regarded liberal arts credential institution and a degree from a well-regarded, effective career school are both great degrees, you know, but the department decided to draw that distinction. The borrower relied on the misrepresentation about the admissions data to his detriment because the misrepresentation factored into the borrower's decision to choose the school over others. However, the borrower received a selective liberal arts education, which represents the value that he could reasonably expect and gets no relief. Interesting. Risk management lesson. Monitor closely representations made to third parties by any person or department affiliated with the institution. So what I'm really trying to focus on out of this particular example is the idea that the representations that were made that misled the borrower were not actually made by the school directly, right? They were made by that third-party service, a U.S. News and World Report, for example. And that's what the borrower relied upon, was the ranking in U.S. News and World Report. But, of course, that data was calculated using underlying information that had been provided by the institution. The other thing, to the department's credit, that they pointed out in this hypothetical, as an aside, was that the department might determine separately that the school violated the Title IV requirements that it not make substantial misrepresentations, which constitutes an enforceable violation. So I want to make very clear to anyone who might be with a selective regionally accredited institution out there, right? What the department is saying is, in this case, we don't think the borrower should get relief because they still got what they ultimately bargained for, right, which was a liberal arts education, and that's what they paid for, right? But separately, if you were to provide falsified data to U.S. News and World Report, that could constitute a substantial misrepresentation. The department might act against you separate and apart from any borrower defense proceeding. Now let's talk about the individual claim process. So we've talked about, you know, when do you have a borrower defense claim and what might the department do with regard to various types of claims that might be made. But now the question is, how do they do it? What's the process? So it works kind of like this. The borrower would submit a claim application and its evidence to the department. Remember, you no longer have to have a prerequisite recovery or collection proceeding. The department would immediately grant forbearance and suspend collection. That's in the law. Then the department would designate a staff member to review and resolve the claim. They have indicated in the commentary accompanying the rule that this staff member would be someone who's independent, right? But at the same time, that does not mean that it's an administrative law judge or someone of that nature. It could still just be a staff member at the department. That staff would notify the school of the claim, and then the staff would review the evidence, records it got from the department, and any school submission that it might receive. Upon request, the staff would provide to the borrower the relevant evidence upon which the staff's decision was made, and then the staff would issue a written decision and notify the borrower of that written decision. In accordance with the time limitations we've discussed above, the department would initiate a separate action against the school to establish liability and recover the amounts owed. A couple important points. A borrower can request reconsideration at any time based on new evidence. And that's evidence that was not previously provided, that's relevant and wasn't identified in the final decision as evidence that the decision relied upon. The department can also unilaterally reopen a claim at any time to consider new evidence. So one of the concerns here, again, from a risk management standpoint, is these things never die. I mean, it would seem like they could keep being reopened as long as either the department or borrower felt like there was new evidence to consider. The department can initiate a recovery action against a school at any time for claims based on judgments against a school for 6 years where claims are based on a breach of contract or substantial misrepresentation, and at any time if the school had notice of the claim before the noted periods expire. So that's that similar construct that we saw earlier and talked about. Lots of procedural concerns here, right? I mean, when I go through that quickly, it doesn't seem so bad, but, there's no independent hearing official. The department's not required to supply any evidence to the school. So I said, well, they'll consider a submission if you give it, but there's nothing in the law that guarantees that the school will actually get the evidence that was provided by the borrower. The school's not guaranteed a right to respond. It just says the department will review the submission, anything that the school gives them. There's no guaranteed time frame for a response, meaning, again, for a school. The department's not required to provide the school with its written determination. The school has no right to request new review based on new evidence that it might have, even though that is explicitly granted to the borrower and to the department. There's no discussion of how the process would work for the department to recover if it did determine that the school owed some sort of liability, or if it granted relief and then wanted to recover against the school. We don't know what that process would look like. And there's no discussion of an appeal opportunity if the department does decide to come after a school. Here's the incredible thing. So after the proposed rule, you all remember, if you sat in when we did our series on the proposed rule, we, in much more detail than I just went through, we cited all of these procedural concerns, and there were many, let me tell you. Interestingly enough, the department punted on the procedures. So they essentially acknowledged that they did not have it all worked out and that there were a lot of holes, but because they had to hit that November 1 deadline of this year in order for these rules to become effective by July 1, 2017, and because they didn't want to miss that deadline, right, they simply punted. They said, Ed has indicated it will outline more specific details about the process for schools and borrowers in forthcoming procedural rules. And then they said, with regard to recovery actions, we'll ensure an opportunity for the school to present its defenses and be heard. So they acknowledged that that was needed. They said the process will be comparable to the types of processes we see right now in Subpart G and Subpart H, that it would be conducted by an independent ED official, although, again, it's not clear exactly what that means. And they also said an appeal option may not be provided because they don't feel that they're obligated to provide any type of appeal option. But none of this was actually worked out in the rule. So all of these procedural concerns were not addressed. Now let's talk about the group claim process. In the group claim process, so because I haven't talked about this in as much detail as I have in past presentations. What this means is, so borrowers can initiate a claim themselves. So they can actually pull down an application offline, fill it out, and send it in and say, you know, I want relief. But I mentioned earlier in that hypothetical, I said if the department was driving down the street and saw the billboard, you know, the department unilaterally could decide to initiate an action against a school, right? And what's important to note is this is like a class action. It's a group claim. So they could say, we're going to initiate an action on behalf of every borrower who drove by that billboard for the period that that billboard was up, right? And you don't have to have any borrower who's actually filed an individual claim, right? So there's a lot of discretion, in other words, for the department, in this case, if it doesn't like a school, or to think about how it might get at that school. Now, that's a very cynical view on my part, but part of my concern is you're creating a construct here that would enable an administration that wanted to target institutions, right? And there's this real question of how this would be administered fairly, or if it would be administered fairly, because essentially the mechanism allows them to just manufacture, I'm not saying without evidence, but out of thin air, as long as they're, like I said, driving down the street, if they see the billboard or whatever, a group claim. They don't actually have to have a claim that's been filed by a borrower, okay? So the department would initiate the claim on behalf of the group. And then they would designate staff, likely an attorney, in the department's general counsel office to represent the group, and then they would notify the borrowers, just like you have a class action, you notify the members of the class. The department would notify the school of the claim, the proceeding, and the procedural rights. That's new. That wasn't even in the proposed rules, so there was some addition of process there. Hearing officials would consider evidence and argument from the department staff and the school, so this is probably an administrative law judge. And then the hearing official would issue written decision on the forgiveness and the liability. And this is interesting. There's been a little bit that's fuzzy this for me in the way that this rule was proposed, but initially, at least under the proposed rule, the idea was we had individual borrower defense claims. It was a two-step process. The first process was overseen by staff, and that was just to determine if there was any relief to be granted to the borrower. And then there would be the second proceeding initiated to recover against the school. Here, the hearing official, the administrative law judge, simultaneously determines the forgiveness and also determines the amount that the school has to pay back. So establishes the liability in the context of this single proceeding. All parties would receive copies of the decision. The staff or the school may appeal the decision to the secretary, and then the secretary issues a final decision. What's interesting is, and this is what I said fuzzy things for me a little bit, in the final rule there was this language included that said, the department initiates a separate recovery action against the school in accordance with the various time limitations, or suggested that they would. So what's interesting to me is I guess that means in the separate recovery action, at this point, they're not trying to establish the liability because the ALJ has already established that liability. This is strictly to recover. Whereas in the context of the individual borrower defense claim, my understanding is that at level 1, the staff member is only responsible for granting relief, and the secondary proceeding would also have to not only serve to collect from the school, but to establish the school's liability. All of that is a little unclear. Again, though, if relief for the group has been denied, and so this is an extremely interesting point, and that a lot of people argued with in the comments to the proposed rule. In the final rule, it also states that if relief for the group has been denied in full or in part, a borrower may still file an individual claim based on the same underlying act or omission. So, in other words, if the ALJ says, no, we don't think that the billboard constitutes a substantial misrepresentation, all of those borrowers can turn around and file individual claims with department staff members for the exact same thing. And it's unclear whether or not that staff person at the department would be bound by the ALJ's factual findings or legal findings with regard to the group claim. This seems extremely problematic. I'm sure the lawyers that are listening in, would immediately, the concepts like res judicata come to mind, and you think, boy, how can you essentially litigate the exact same facts twice? The department may reopen a claim at any time, once again, to consider new evidence. So the department can initiate a recovery action against the school. This is just with regard to the timetables. Once again, and you've seen this slide now a couple of times, at any time for claims based on judgments against the school, for 6 years where the claims are based on breach of contract or substantial misrepresentation, and at any time if the school has notice of the claim before the noted periods expire. Once again, there are a lot of procedural concerns. The department's not required to provide the school with evidence filed in support of the claims. They're not required to identify to the school the evidence they consider relevant. The school's not guaranteed a right to respond to the department. No time frames are specified. Appeal right is guaranteed, but there's no process for the appeal that's specified. And the new rules suggest a separate recovery proceeding, but again, there are no procedures discussed for that proceeding either. And once again, the department has punted. So they stated, the department understands commenters' concerns regarding the broad guidelines for the group fact-finding process. The department is developing procedural rules to govern the fact-finding processes, which will establish these details more firmly and be informed by the procedures and protections established in Subpart G and Subpart H. All right, so this is the last little section. So let's say you've gone through this proceeding, the department has determined that relief is appropriate, right? But now the ALJ is trying to determine how much relief exactly to grant. The amount of relief is going to be determined by the department, and it can range anywhere from nothing, right, to all amounts previously paid by the borrower and still owed, plus any associated costs and fees. This does exclude non-pecuniary damages like inconvenience, aggravation, emotional distress, etc. Relief is offset by any financial benefit already received by the borrower and related to the borrower defense. So that's an important point. What the department is saying is, let's say that the reason you have a borrower defense is because there was a judgment, right? But let's say as part of the judgment against the school already had to pay off all your loans and, pay back a whole bunch of money. What the department is saying is we're going to take that into account. And that's an important point too. But under the new rule, setting aside those two notions, the methodology used to calculate the relief, what's interesting is it now varies based on the nature of the underlying claim. In the proposed rule, the department had come up with sort of 4 or 5 different guidelines for how ALJs might go about determining relief, and they've replaced that with this approach. So for a judgment against the school, where the judgment awards specific financial relief, then the relief will be the amount of the judgment that remains unsatisfied, up to the amount of the loan. So again, you can't get back more than the loans. Where the judgment does not award specific financial relief, the department will, quote, rely on the holding of the case and applicable law to monetize the judgment. So anybody's guess. Breach of contract. Relief will be determined according to the common law of contracts, subject to the loan cap limitation and any other reasonable consideration. So this gives you a little bit of comfort if you've got a breach that was non-material and should not have had any sort of financial impact on the individual, right? Because the common law of contracts is going to come into play and mitigate any type of exposure for the institution. Substantial misrepresentation. This is the most interesting. So the department will balance various factors, right? The cost of attendance, the value of the education received, the value of the education that a reasonable borrower in the borrower's circumstance would have received, and the value of the education the borrower should have expected given the information provided by the institution. I think this is where, given the behavior of the department over the last 4 to 8 years and its obvious dislike of certain sectors of higher education, you would have significant concerns, right? Because you're creating a construct that gives the department the discretion to place a value on the education received. And if you've got an administration that takes a particularly dim view of your sector, they may determine that there's not a lot of value there. On the other hand, if you are a selective regionally accredited liberal arts institution, like used in some of the department's examples, they may feel like there's a lot of value to the education received. And that could impact how they determine the relief, despite the fact that the two institutions engaged in an identical substantial misrepresentation, which doesn't seem appropriate. But this is how the rule works. Schools have the burden of proof regarding the value of their education. So the department is going to require you, the institution, to substantiate why you think your education has value. And finally, these are our resources. You know, we have our blog. I think I've mentioned many times to the folks who tune into these webinars. Regucation, we like to write about lots of different things, including bar defense, and we also try to post anytime we're going to do webinars and things like that. So please feel free to check out the blog at your discretion. And that's me. And with that, we'll take some questions. Are we responsible for vendors that we do not have contracts with using our school name or likeness in their marketing? Well, that's a complicated question. I mean, I'm curious as to why you've got vendors using your logos and intellectual property if you don't have any contract with them. I mean, as a starting point, you might want to. But, you know, I think there could be, I think a regulator, the department, or anyone else, if you have a functional relationship with them and you are paying them and you have an understanding and they are acting on your behalf in exchange for that payment, then the department would probably say, well, you do have a relationship with these folks. It may not be in writing, but you've got a performance relationship. So I think there could be some exposure there, certainly. What do you think about using stock photos in advertisements? Yeah, I mean, I think that's fine, but you just have to be aware of, if you're, you know, and the example I used earlier was if you've got, say, a culinary program, and you have in the background behind your student or chef some beautiful-looking facility, and it looks like an educational facility, like the inside of a kitchen or something that student would be, you know, where they would be getting their education. Whether it's a stock photo or not is not the issue. The issue is it's not real. That's not, and it gives the impression potentially to someone driving by who sees that billboard that this is in fact your facility and could induce a student to enroll thinking that they're going to get to go to school in that beautiful space. So I think you've got to be, you know, mindful when you use stock photos. Are the stock photos are you giving the impression that whatever is in the photo is somehow your institution or the facilities that you have? You know, if you have a study abroad program to London and you want to include a stock photo of Big Ben, I don't think that's a problem. I don't think anyone's going to think you own Big Ben, right? You're just showing a picture of London. But you have to be mindful about that kind of thing. It's a great question. The DOA has a 3-year file retention regulation, but students can come back after 15 years. We would have no documentation left. How do we prove this with no file? That's a really, I think that was supposed to be the Department of Education. So yeah, super interesting question. So interestingly enough, the reason that the department originally limited its ability in that first regulation, the current bar defense regulation that's still in effect, not the new one, you recall we started out at the outset and we said it was only 3 years that the department had to come after you. That was because it actually doesn't even say that. What it really says in the regulation is it ties it to the record retention requirement. So that's a great point. And what the department said in the preamble to the final regs and its discussion of the proposed regs, because a lot of people made this point. They said, well, we don't think that's really going to be a problem for schools anymore because the fact of the matter is most schools have these records. In fact, many of them are keeping records for a longer period specifically to mitigate against the risk of litigation and things like that. But you make an excellent point, and I'm not sure that the department's logic holds water. I mean, just because there are some institutions out there that may have determined to maintain some records does not mean that institutions are going to be keeping all of the records they would need to defend themselves. But you're right, if you get rid of those records, then you are not going to have anything on file that would allow you potentially to counter the student's allegations or the borrower's allegations. Do you think we need to start putting disclaimers on photos like your results may vary on graduate stock photos? We profile a lot of successful grads, but clearly their success isn't solely because of their studies with us. Yeah, of course. What is a reasonable disclaimer to indicate that this result is also due to their work and experience and other studies and personal attributes? Well, I don't think you need to put your results necessarily need to put something like your results may vary on every picture of a graduate that features a testimonial or something like that. But I do think it's important somewhere in your catalog or perhaps in your mission statement on your website, other places where you talk about your programs and your graduate success. Typically there's somewhere that it is appropriate to include language that makes this very point. You know, that you as an institution are going to make certain types of efforts to educate folks and provide them with certain things, but certainly, you know, their specific, whether and to what extent they experience success will also be a product of the effort that they put in and their particular circumstances. And I think it is important to include that kind of language somewhere. Also, you need to make sure that your admissions reps and the people who are having conversations with students when they're thinking about coming to your school have that type of language in mind. Right? And that's really where the rubber hits the road. You know, it's probably not going to be because you've got a picture somewhere of a student and a testimonial next to him or graduate that says, oh, you know, I had a great experience. This is why I chose to, you know, go here or there. But it's in those conversations where you want to be real clear about that. If you have an enrollment agreement, if you're a for-profit school somewhere or otherwise have one, you know, you might want to include something along those lines in the enrollment agreement. And for any kind of school, again, I think it's important somewhere on your website or in your printed materials to have that kind of discussion with students. Let's see. Many schools have been abused by scammers with our logos and names. I believe that is the concern. Are we liable for those misrepresentations? No, look, I think if you can demonstrate to the department that you have no relationship with a third party, and that they are in no way acting on your behalf or pursuant to an agreement, I don't think you have a concern, right? I mean, you may have concerns, but I don't think the department is your concern, right? I don't think they're going to say you're liable for that. But if you're paying someone to go out and build microsites for you and advertise or provide you with leads or do some other type of marketing or advertising for you, my point is even if you don't have a contract with them, that isn't necessarily dispositive. You could still have exposure there. Let's see, do you know of any examples where schools were found to violate misrepresentation rules for indicating something that was true? Well, what I can tell you is that I know that the department has asserted, and I've seen them assert, where representations made, though they were true, were misleading because of the context in which they were made. And in fact, I don't know if you recall, probably not, but on that slide where I showed you the big definition of misrepresentation, the little bit of red in the middle that changed was the department explicitly changed it to point out that a misrepresentation could include a representation that is a tendency to mislead, and then they added that language that I'm paraphrasing, but it basically says, you know, in the circumstances in which it was presented. And I do think that's what they're getting at. And I've seen the department go after schools in recent years regarding representations concerning employment or placement rates and things like that. And it's not that the representations themselves were inaccurate. It's that they were presented in a way that the department believed was misleading. Because you didn't properly explain the methodology, or you know the representation. The student would have thought, given the way it was presented, that it was a placement rate, and really it was an employment rate, that kind of thing. Even though the representations themselves are in and of themselves accurate. If an ownership change occurred within the past 5 to 10 years, and a student from more than 10 years ago comes forward, will the department take the ownership change into account? Yeah, really interesting question. So the department historically, they view regulatory liabilities as attached to the institution, right? So if institution X engaged in substantial misrepresentation, and then a new owner came and acquired the institution, that would not change the fact that 15 years later, the graduate is still saying that institution X engaged in a misrepresentation. The new owner would almost certainly, from the department's view, have assumed those liabilities when it became the owner of the new school. What was the name of the procedure you mentioned early in the presentation by which Congress can contest this rule's implementation? The Congressional Review Act. And if you Google right now, Congressional Review Act, you'll get lots and lots of hits, because this is a big topic of conversation, not just in Department of Ed, higher ed circles. I mean, there are lots and lots of rules that have been proposed by lots of different agencies in the federal government over the last 4 to 6 months, and many of them are potentially the subject of a Congressional Review Act type piece of legislation, right? So, and that's actually gets back to one of the points I was making earlier, is that, you know, I believe the Congressional Review Service, which some of you may know, is Congress will actually ask these folks, as sort of a group of scholars in the federal government, to write reports on things that they want to know about. And so they write these reports and they actually give them to Congress to review, and Congress uses those to sort of inform their decision making. And so, as you can imagine, a lot of people have been asking CRS to produce information about things like the Congressional Review Act and, you know, regulatory implementation, all those kinds of things. And I believe about 2 weeks ago, the CRS put out a piece that was all about the Congressional Review Act and how it works. And I've seen, there's press too. There's no shortage of news articles, but if you really want something that looks more like a, you know, a report on how the Congressional Review Act works, that's what I would look for. Congressional Review Service, Congressional Review Act. Maybe just Google those things. But the point I wanted to make is they highlighted lots and lots of different rules that could potentially be subject to a CRA piece of legislation, and this was not in it. This didn't even make the cut in terms of the list that they just threw out. So that gives you a sense of how many other things there are that Republicans, because it's going to be the Republicans, are thinking about right now, right? And that's why, going back to the beginning, if you don't like this rule and you want to make sure that it's dealt with as part of a CRA or otherwise, you definitely want to be letting folks know who can communicate that message. During the process of meeting with a potential borrower, how can an institution protect itself from potential claims where students indicate they needed to make decisions immediately? There would be unfavorable consequences if they delayed enrollment loan decisions. They were discouraged from consulting others. Okay, let me get through this again. So, during the process of meeting with a potential borrower, how can an institution protect itself from claims where students indicated that, I guess, that they were pressured into making decisions immediately, there would be unfavorable consequences if they delayed, et cetera, et cetera? Well, that's a hard thing to do. If you are a nonprofit institution or a public institution and you don't have an enrollment agreement, it can be difficult to find a place potentially to capture this, although you may have some sort of orientation materials or things, code of conduct that you ask students to sign. For the for-profit career schools that typically have an enrollment agreement, not only could you could design a separate disclosure that literally has these things the department has listed and has the student certified that, you know, they were not subject to any of these things. But even, you know, if you don't do that, I would say in your enrollment agreement, you can include an attestation or certification at the end that basically gets at this idea. And when I design enrollment agreements, and giving credit where it's due, I credit Roger Schwartzwelder, some of you may know, with giving me this idea years ago. But I include at the end of an enrollment agreement what I call student attestation. And it basically says, you know, and I have the students initial it specifically, and it says, you know, among other things, I confirm that the oral representations that were made to me in the context of our enrollment agree with and are consistent with the written representations in this document, because that's going to be one of the first things people always say is, well, I know my enrollment agreement or those disclosures say X or Y, but that's not what I was told. So now you've got this specific affirmation from the student that's been initialed where they said, no, that's not true. And then you could also include something along these lines that says, you know, I made this decision, I was not pressured, I was not told, you know, X, Y, or Z. They could still claim down the road that they were pressured and that the representation didn't match with what was in the enrollment agreement. But what you can at least do as an institution is take what steps you can to try to defend yourself against that. And the best way I know to do that is to try to have a really plain statement that they would initial in that documentation. Let's see. Should we expect any quantification of value of education or reasonable reliance, or will these be a subjective determination by the department on a case-by-case basis? the latter. I'm sure that they will be a subjective determination. Over time, if this rule sticks and the department builds up enough decisions and your ALJs are making decisions, you know, you'll get a body of law and decisions that will sort of start to provide a context for how they ought to work out. And you would be able to argue or expect some consistency from adjudication to adjudication. But certainly as of right now, all the law says is schools have a burden of demonstrating the value of their credential. And, you know, the real frustration I would have is I don't even know what that means, right? I mean, I don't even know what the department considers value. Is it marketability? Is it what employers think of it? Is it how much money you can earn after you graduate? I mean, if I'm offering a comparative literature credential, how do I compare the value of that, you know, at a liberal arts institution to the value of an HVAC associate degree at a career school? I mean, as you all in education know, these are extremely different educational products. They're intended for different purposes. You know, they deliver different types of content, potentially through different modalities. I mean, the comparative literature degree could be online. They're just totally different. And we have, not only do we not have standards for how value is to be determined, you know, I don't even know what the department considers to be value. I could make some guesses, but really the point is we need to know that. Isn't harm or detriment to the borrower a key component of substantial misrepresentation? You didn't emphasize that. Okay, well, fair enough. So I'll emphasize it again. Absolutely. And if you look back on the slide, what it says is, in order for it to be a substantial misrepresentation, it is a misrepresentation, as that term is defined under the law, that either a borrower relied upon to their detriment or could reasonably have been expected to rely upon their detriment. So to answer the question, yes and no. Yes, the element of detriment is there, but the student does not actually have to have experienced detriment to establish a substantial misrepresentation. They just have to establish that they could have been reasonably expected to have relied upon it to their detriment. Now, that's just to establish that a substantial misrepresentation occurred. If the student wants to establish a borrower defense claim based on substantial misrepresentation, then they have to go the next step of showing actual reliance. But again, and here's the other point I want to emphasize, they have to show actual reliance to their detriment, but the detriment doesn't have to be material. Right? And this is a concern to me. So I would have a valid borrower defense claim if I could substantiate or show that I actually relied on the school's misrepresentation, even if the detriment I experienced was extremely minor, right? Now, the hope is that the department, in turning around and determining the relief to grant, would take that into account. But again, this leads you down the road of now it's in the department's discretion, and how will the value of my credential be determined, and what does it even mean to have value, and how do I establish that, et cetera, et cetera. I mean, my view, and when, you know, we authored lots of comments to the proposed rule, and we said you ought to just have a clear materiality standard up front, right? So that, and for that matter, I mean, it'd be nice if there was an intentionality standard. Although, as the department pointed out in its discussion back in 2010, when it changed the definition of misrepresentation, substantial misrepresentation, and now, it is true, there are many Consumer Protection Act standards around the country in different states that don't require a showing of intent. And the department took the view that they would not include intent specifically in that definition, but they indicated in their conversation back in 2010 that when they were deciding whether or not a substantial misrepresentation had occurred, they would take into consideration the context, right? What if we found out an employee misled potential applicants to the school? An so like some former representative guaranteed employment, and has since been disciplined. How serious is this situation? Well, unfortunately, even if it's a former employee, if they misled while they were in your employ, then it's still a misrepresentation. So you would have whatever exposure would come with that. How serious it is would depend on the nature of the misrepresentation and the extent to which the student relied upon it, you know, and how much harm they may have suffered, all those kinds of things. But the fact that they're a former employee doesn't change the fact that they engaged in that misrepresentation while they were in your employee and on behalf of the institution, while they were in your employ and on behalf of the institution. Let's see, since this is the Department of Education, shouldn't we be looking at educational value? Wouldn't that be Wouldn't that be reasonable? Yes. I mean, I think when they say the value of education, that is what they're talking about. But what I mean is, what I don't know is how they quantify value of an education, right? I mean, what does that mean? Again, does that mean does that mean gainful employment? You know, so how likely is the education to lead to employment of a certain type or making certain money, or is it, you know, because a lot of liberal arts institutions, which are subject to this rule, would point out rightly that they don't necessarily offer their education to prepare people for gainful employment, right? I mean, you're educating people truly so that they can learn to be a thinker. Right, so, and they may go off and be a scholar or a writer or not seek employment or an artist of some sort. I mean, that's not the point of the education necessarily. And this is a bigger debate, obviously, and lots of people have a lot to say about it. I'm not trying to set that off, but it just goes back to this idea of, you know, we've got this one rule that's supposed to fit all here, but when you talk about determining the value of an education, education is a really big word, and so is value. And my point is we have no concept of how the department now or the next administration or the administration after that might determine value. And that's a concern to me, that you're creating a standard here that could be interpreted in extraordinarily different ways, you know, year over year over year, potentially. Well, I should say administration after administration. Can you repair misrepresentations with a later correction? Yeah, that's really an interesting question. You know, you can't undo a misrepresentation, but you could try to show, I think, that you took some sort of corrective action that mitigated any damage that the borrower may have experienced. So let's go back to that breach of contract. Well, that's not, I guess that's breach of contract, not a misrepresentation. Let's say you represented to a student, we're going to have tutoring on Tuesdays and Thursdays, right? Turned out that's not true. It's on Wednesdays and Fridays. But then you went back to the student, second week of class, and you said, hey, it's actually going to be on Wednesdays and Fridays. Is there anything we can do to accommodate? I mean, I would think if the student said, well, that was a misrepresentation and induced me, you know, they might be able to establish that on its face that's true, that something was said that was not accurate or not true, right, at the time it was said. But if you immediately, for example, took corrective action and tried to work with a student to mitigate any detriment, you know, to try to prevent or mitigate any detriment they might experience, I would think that that would become part of the department's consideration when determining whether or not to grant any relief. So all of this is just to say, I think there is a role here for common sense. I really do. And truly, it may be the case. Truly, it may be the case that if administered by well-meaning, common sense folks, that this would all work. The problem is that as an attorney type like me, you don't want to rely on that, right? I mean, you want to the best of your abilities to design a system that will take care of itself with the assumption that you may end up one day with a bunch of folks administering this system who aren't well-meaning or competent, right? We survey students and grads regarding whether or not they got value. Would that hold weight? Yeah, maybe. That's interesting. Yeah. Certainly, I would think graduate surveys could be a useful tool if you're trying to establish to the department the value of your educational product. Absolutely, I would think that would be a useful tool. So that's all the questions, and it's 1:47. Thanks to everyone for tuning in. Always very much appreciated. And we're on again on Thursday and then a couple of days next week, and hope you'll join us again for those as well. I'm Erin Lacey. Have a great afternoon.